Form 2848 is the IRS power of attorney. It's the taxpayer's written permission for an eligible person to represent them before the IRS and to receive confidential tax information. On the EA exam, don't confuse getting info with acting for the taxpayer. If you're advocating in an audit, appeals, or conferences, you're in POA territory. Form 2848 has strict completion rules. You must list specific tax matters and specific periods. All years or all taxes gets rejected. Past periods can be listed normally, but future periods are limited, no later than 3 years after the IRS receives the POA. Also, each taxpayer needs their own Form 2848, even if they filed a joint return. Representatives have to be eligible to practice before the IRS to sign Form 2848. They sign a declaration of representative and attest they're subject to Circular 230. That's a big deal because it gives the IRS authority to regulate the representative's conduct. Also, the rep uses their own name, not the firm's name, and includes their PTIN. Unenrolled individuals can sometimes represent taxpayers, but only in narrow situations. Think family members, fiduciaries like executors, or an unenrolled preparer who has an AFSP record of completion and prepared the specific return involved. On the exam, if the person is just a preparer with a PTIN, that's not enough for representation rights. 2 easy traps: delegation and who is authorized. A POA can't be delegated to an employee who isn't recognized. If Beatriz is the only enrolled practitioner, only Beatriz is the representative. Her corporation and staff aren't. And remember, one Form 2848 can list up to 4 representatives, but only those named and eligible have authority. POAs also change over time. A representative can withdraw by writing "withdraw" and submitting it to the IRS. A taxpayer can revoke a POA, and they don't have to name a new representative to do that. And if a new POA is filed for the same matters and periods, it generally replaces the prior one, so the new rep takes over. Finally, don't confuse Form 2848 with other authorizations. A third-party designee on a tax return can get limited info, temporarily, like checking a refund status. But that's not representation. On the EA exam, if the task is advocate, negotiate, or appear, you're thinking Form 2848, not a simple disclosure consent. In which instance is a power of attorney required? Is it allowing the IRS to discuss return information with a fiduciary, advocating for a taxpayer during an IRS examination, providing information to the IRS at an employee's request, or authorizing disclosure of tax return information through written or oral consent? Think about what crosses the line into representation. The correct answer is advocating for a taxpayer during an IRS examination. That's representation, so you need Form 2848. A tempting wrong choice is authorizing disclosure of information because it sounds official, but disclosure consent is just permission to share info. It doesn't let someone argue, negotiate, or act for the taxpayer in an exam. Which statement is not correct about changes to powers of attorney? After substituting a representative, only the newly recognized representative is considered the taxpayer's representative. A taxpayer must authorize a new representative when revoking a POO. A recognized representative can delegate authority to another recognized representative if the POA specifically allows it. Or a recognized representative can withdraw from a matter where a POA was filed. Think about it. The incorrect statement is that a taxpayer must authorize a new representative when revoking a POA. Revocation just ends the old authorization. No replacement is required. The tempting choice is the substitution statement, but that one is generally true. When a new POA replaces the old one for the same matters and periods, the new rep is the recognized representative.